So, สวัสดีครับอาจารย์ Dr. Schuldt, thank you so much for being with CPG today. First question is about the current critical issues. What is going on now with ICC?
Yes, thank you very much, first of all, for having me. The current critical issues regarding the International Criminal Court are mainly two issues that we can refer to. First of all, the situation regarding African countries is quite interesting. African countries have now, in the recent years, adopted a more and more critical opinion towards the International Criminal Court. A number of African countries have said that the International Criminal Court may be biased against African countries. Why would they say that? Well, they say that because currently 10 out of 11 situations which are dealt with by the ICC are situations in Africa. There's only one other situation in Georgia, but the vast majority of cases are African countries, so that some African governments now said this is a biased situation. And interestingly, one country in Africa has already withdrawn from the International Criminal Court statute. That is the country of Burundi. Two other countries, South Africa and Gambia, also first withdrew but then rescinded their withdrawal and joined again. But there you can see some critical situations in Africa where the acceptance of the ICC is currently put into doubt. The second issue that is also a critical issue is the question about what is the relation between international criminal law and immunities.
Let me ask you straight to the same questions. Do you think which one is stronger than the others?
That is, so the question, to what extent are international immunities or diplomatic immunities still protected against international criminal investigations? I would say the current situation is just unclear. The customary international law has developed already into a direction towards the acceptance that international criminal law and the prosecution of these worst crimes, that is more important than protecting the diplomatic immunities. However, you can see that a number of countries, particularly here in Africa, see that differently. And that is a very strong sign also for the development of customary international law, the practice and the opinion of governments as well.
When diplomatic immunity still can be used, it means why should we care about the international criminal law?
Right, but we have to say that as soon as you are a member state to the ICC statute, then you cannot raise immunities anymore.
How about the issues in Southeast Asia countries? Do we have any issues, or how about the number of the memberships?
Right, so in Southeast Asia we currently have very interesting developments. On the one hand, just recently Malaysia has joined the ICC and has become the 124th country to sign the ICC statute and to become a member. At the same time, however, the Philippines is about to leave the ICC. The Philippines has in 2018 notified that it wants to withdraw from the ICC statute, and this is becoming effective now in March 2019. So therefore, these two countries are quite an interesting situation. The other member that needs to be mentioned in Southeast Asia is Cambodia. That makes Southeast Asia a region with a very low membership with regard to the ICC. The question can be asked, why is that so? Why is the membership so low in Southeast Asia? And there it is quite interesting if you take a look at the Rome Conference of 1998, where the ICC statute was negotiated. Because at that conference, countries from all over the world and also many Southeast Asian countries joined in that conference to discuss the content of the ICC statute. What did Southeast Asian countries say and what were their criticisms? And you can, for example, see that one point of criticism that they raised was the possibility that the independent prosecutor of the ICC can bring cases to the ICC. That means there it would not be necessary that a member state refers the case to the ICC, but the prosecutor himself can do it. And there are some Southeast Asian countries, for example Indonesia but also Malaysia, have been quite critical about this very strong position of the prosecutor. Another issue that was raised by Southeast Asian countries was the possibility that the United Nations Security Council can refer cases to the ICC even though a country is not a member state of the ICC. So there was also some discussion to what extent can the Security Council be considered independent and neutral, or is it maybe politicized or biased? So that was also one worry that was shared by some Southeast Asian countries. At the same time, we need to mention that Southeast Asia and ASEAN, the Association of Southeast Asian Nations, is an association which has always been based on the principle of non-interference. That means any intervention or any interference with domestic affairs is prohibited. And that also demonstrates that Southeast Asian countries are quite aware of their national sovereignty. The ICC as an international institution could investigate, if necessary, issues which take place in these countries. At the same time, however, I personally think that this criticism, or this fear, you may say, is not really justified, because the International Criminal Court functions according to the principle of complementarity. That principle says that the International Criminal Court is allowed to investigate only if that particular country itself is either unwilling or unable to investigate the crimes under the jurisdiction of the court. So the principle of complementarity says if a country does not investigate allegations of crimes against humanity, genocide, war crimes, or aggression, then the International Criminal Court can investigate that situation. So that means if a country takes its full responsibility to investigate issues which may amount to these crimes, then the ICC will not step in and will not investigate.
Like, is there any investigation issues going on in Southeast Asia?
Yes, currently in Southeast Asia there are two preliminary investigations. One preliminary investigation is dealing with the so-called drug war in the Philippines. As you may know, since Rodrigo Duterte has entered the presidential office in the Philippines, a campaign to fight drug and the drug trade has been started, and this has resulted in a number of extrajudicial killings. The numbers are still disputed, but we can say between 2 to 10,000 people have been killed without a trial. And this situation has then been investigated, or is now being investigated by the International Criminal Court as a preliminary investigation, because this may amount to crimes against humanity. Crimes against humanity means that this could be a widespread or systematic attack against the civilian population. And if you see here the numbers, which go into the thousands, it may not be ruled out that in the end the ICC may consider that this is widespread or systematic. At the same time, however, as I mentioned already before, according to the principle of complementarity, if the Philippines and if the Philippine courts would properly investigate these charges, and if there will be convictions of persons who have committed these crimes, then the ICC would take that as an evidence that the ICC would not need to investigate this itself, because the Philippines is itself able to investigate this. The second situation in Southeast Asia relates to the Rohingya issue in Myanmar. The incidents of the Rohingya persecution in Myanmar have been labeled by representatives of the United Nations as a probable case of genocide. That has then also sparked the investigation, a preliminary investigation by the ICC. However, Myanmar is not a member state of the ICC. That means without a referral from the United Nations Security Council, the ICC could actually not investigate this if Myanmar does not want to accept jurisdiction of the ICC on an ad hoc basis. That is also possible. A country can, even though if it is not a member state, can on an ad hoc basis also say, for this particular case, we will accept the ICC jurisdiction. However, Myanmar has not done that. So how can this case be then treated by the ICC if Myanmar is not a member state and if there is no Security Council referral? The possibility that has now been found is that Myanmar's neighboring country, Bangladesh, is a member state of the ICC. And as you may know, the incidents that took place in the state of Rakhine in Myanmar have resulted in a mass exodus of about 700,000 Rohingya people to Bangladesh. So that now the preliminary investigation focuses on those acts of probable deportation from Myanmar to Bangladesh, so that then there is a connecting point in Bangladesh, which is a member state of the ICC and which gives then the possibility for an investigation.
Would this mean the ICC can do the investigation in Myanmar?
That is a very interesting question. So the ICC is usually relying on the cooperation of its member states. Now, Myanmar is not a member state, so therefore Myanmar does not have any duty to cooperate with any investigation. That would, in the end, make an investigation very, very difficult and very unlikely to be conducted in Myanmar territory. So currently it seems that the preliminary investigation is focusing on what can be investigated in Bangladesh, but we will see in the future how this develops and to what extent Myanmar may be willing to cooperate in this investigation.
For today, about the explanation of ICC, ขอบคุณมากครับ Thank you so much for your kind and give us the very important information about the current issues and some background of ICC. ขอบคุณมากครับ
ครับ ขอบคุณครับ Thank you very much.